for the initial 5 lectures, we've been talking about the background legal point or the authorities. And then for the 6th lecture, we talk about, well, something which is not exactly succession. And then for these coming 3 lectures, we will try to go through the actual application for probate. Now, it's not difficult, but it may be confusing if you just come in as a green harm. There are various questions that we should raise in order to take us to the right door to get in. One of the most important thing is this legal concept of domicile. You have to try to find out what exactly was the domicile of the deceased at the date of his death. Domicile basically is a common law concept before we have the domicile ordinance, which kind of consolidate the common law position. And basically, domicile is something that is to be looked upon or to be determined by 2 factors. Number 1 is the fact of a residence. Where exactly did the deceased die when he died? Place. And the other thing is the intention. Now, the intention is important because you must have an intention to stay in a place indefinitely or permanently. So if you are purely having an intention to stay in a place where you work, where you travel, or just for a brief visit, then it will be difficult for you to argue that you actually died domiciled in the place you happen to die. And another frequently met problem is the fact that a person died in a place doesn't mean or does not necessarily mean that he died and domiciled in that particular place. He may have died in Hong Kong, and his domicile may not be Hong Kong. If we extend it a bit further, he died in the United States of America. He may not have died domiciled in the United States of America. That is for a different reason. Hong Kong is small enough, even though that we have Hong Kong, Kowloon, and the New Territories. We have a unified system, or the legal system in terms of succession. Meaning whatever is provided, it applies to all 3 places. And so in the United States of America, they have different law in different states. So therefore, you die in the United States of America, but you domicile in a particular state. So the difference between state and domicile can be illustrated here. We mentioned last time about in the UK, then you have a domicile of England and Wales, Scotland, and Northern Ireland. And so, these are the various concepts related to domicile. So we must, first of all, try to establish the domicile of a deceased. And the other thing is, apart from domicile, is whether the deceased died with or without a will. If one died with a will, primarily we can say that probate will follow the will, or succession will follow the will, and more often than not, the will enable probate be applied for. Whereas, if someone died without the will, then she died intestate. When someone died intestate, then you look at whether or not this is a next of kin with beneficial interest, meaning is he or is he not entitled to inherit according to the rule of intestacy, and basically as prevailed or as provided in the place of domicile. And the further thing that may sort of affect what we are going to talk about probate is it is part of the international law that provides for the fact that the priority of inheritance on intestacy may have a difference depending on the nature of the assets. If, when we talk about immovable property, then it is the law where the property was situated that provide for the inheritance. On the other hand, if this is movable property, a while ago I should say is immovable, now this is movable. Movable property, anything which is not immovable is movable, such as cash in bank, shows in action. Shows in action is something which is enforceable only by contract, so it's a actionable right on litigation. Then the international law says that on intestacy, on movable property, it should be governed. It should be governed by the law of inheritance according to the place of domicile of the intestate. So these are the international law. But then, whether an international law is applicable to a particular place is questionable. Like for instance, these days, it's quite common that we may have property in Hong Kong. We may have property in the mainland. Then it's complicated by this movable and immovable concept. And then, apart from movable and immovable, then we will have also the difference in whether a grant is needed. In Hong Kong, a grant is needed for administration of estate, whereas in the mainland, there is no such concept as grant that we understand here. Even though last year it has commenced this concept of estate administration, but it's only talking about administration of estate without reference to the need of a grant. That means in the mainland, they recognize that there is a need for estate administration. But then who that responsibility lies is not clear. It simply says whoever is administering the estate will have some kind of duties, and if they have breached the duty, then they are liable by law, which is now provided in the civil code. Whereas in Hong Kong, we say, all right, you need a grant. After the grant, then you start the estate administration. But then, what happens if a deceased dies in Hong Kong, leaving property in Hong Kong and also leaving property outside Hong Kong in, let's say, San Francisco or Vancouver? Then all this provides for all kinds of problems as to the priority to apply for a grant, as well as on the need to apply for a grant. So these are stuff that have been troubling us, and these are the focus of discussion in these coming 3 lectures on probate in Hong Kong and how this is related in terms of different property or different assets. Now, grant used to be dealt with only by the probate registry. In Hong Kong, unlike the court, in the sense that we have district courts in different places. What I say is the magistracy. The magistracy. And then we also have a district court. And then we also have the High Court. Now in Hong Kong, we do not have any other what we call district registry. This is a concept you run into when you look at the UK textbooks. And here in Hong Kong, we have only one probate registry, which is in the High Court. So you need only to visit one place in order to get your grant applied for. But unlike application for probate, another area which is the administration of estate, which is the subject matter in lecture 10, when there are disputes on estate administration, which is different. Any disputes on estate administration is governed by Order 85, which may be handled by the High Court or by the District Court, depending on the jurisdiction amount. Whereas, applying for a grant, there is no any ceiling differences. Every grant applied for in the probate registry. And over the years, there was some simplified procedure, which is called summary administration. It's first started in the probate registry. In the same probate registry, so there are 2 types of application. One is the regular application for grant. The other is application for summary administration of estate, or what we call summary administration of small estate. In case formal grant, then the grant is issued by the registrar. The person supposed to be in charge of the probate registry, the registrar. The same title, registrar, also carry another capacity, and the registrar is also known as the official administrator. Remember, it's the THE, the official administrator, capital O and capital A. The official administrator is, as I've just told the class, is the different capacity, different role carried on by the registrar. Then it takes us to the summary administration within the probate registry. So it is permissible for summary administration of simple and small estate within probate registry. And no grant is issued, but some kind of letter and certificate will be issued to enable informal administration of estate, not exceeding 150,000. That has been around with us for a long time. Then, gradually, as we have more and more people died in Hong Kong, and perhaps this is one way to try to think of how to simplify or loosen or lessen the workload of the probate registry. So eventually a new creature was established by way of yet again another simplified system, which is summary administration by the Home Affairs Department, which is HAD. So Home Affairs Department summary administration is similar to summary administration by the probate registry. But HAD summary administration is much later development. The present limit is 50,000. In HAD, as well as in probate registry, summary administration is to be made by the applicant in person and without solicitors. No grant is issued. For HAD, you go to Wan Chai, the Southbound Center, and that is their office is established to deal with this estate administration relief. So, since the start of HAD, Home Affairs Department, one sees a gradual departure of grant application in respect of the administration of a deceased estate. So presently, if you look at it from the point of small estate administration, you see it as 50,000 ceiling at HAD outside the court, and 150,000 within the court handled by the probate registry. Whether or not this can be done, in relation to an increased estate, like if you add a zero at the end to increase the value, well, all this is only to be done by way of administrative decision by the authorities. So in other words, let's keep our mind open. Grant application is not something taken for granted or something which cannot be changed, or something it is part of the common law. You cannot say, this is a grant, so this is a common law, so therefore it cannot be changed. The reason why I raise this point with you is when we are dealing with requisitions, when we come to apply for a grant, you can see that a lot of emphasis is still focused on the historical procedure in Tristam and Coot of the UK. Very often they will refer you to T&C, paragraph 1, 2, 3, and 4, and now they change it, amend it, comma, and guide paragraph 1, 2, 3, for instance. If we have a wider mindset, you may ask, why is that we still have to follow the T&C? Well, since 2006, we have our own forms. And on the other hand, we are still using the old rules in the UK, when in the UK they have already have substantial amendment to it. What is the authority to say that we must follow the old rules of UK and say it under, quote and unquote, as a common law system? Looking at it as if nothing is changeable, looking at it as something, if you change it, then you're ruining the common law arrangement. In fact, it is not the case. This is something that can easily be amended. Our argument can go the other way around. In the mainland, they don't have a grant, and they don't have they do not have this concept of estate administration. And yet, since 1985, when they first have the Succession Act, then last year they have this civil code. They incorporate the Succession Act of 1985 into the civil code, and now it's become part of the civil code. And also it has expanded one fresh set of provisions on estate administration. So you can compare the two systems in order to justify, well, we are not talking about which system is good, which system is bad. We are just trying to convince you that the two kinds of systems are constantly making amendments and making changes. It's nothing to say which is better. One thought used to be that, well, like in the last 50 years or last 30 years, okay, we started off with the last century. In the last century, the United Kingdom was leading the world in terms of their influence, in terms of their assets. In the last 50 years, Hong Kong has been able to come through and survive. When you compare with the whole of the PRC, Hong Kong is the place which perhaps is one of the wealthiest. You have 1 million, well, that you can buy a mountain across the border. So it is one way to justify why in the mainland, when they have rules which is sort of yet to be developed, because there is no need for succession. Here, when you die, you have a house. In the mainland, you die, you also may have a house, which is a village house. And what you have is a bicycle, a sewing machine. You don't even have a fridge. Whereas in Hong Kong, we used to have a lot of stuff. One cubicle will cost you 1 to 2 million. So it's a hell of a difference in terms of the economic, in terms of the assets to be succeeded. Now, in your lifetime, you can see that the trend is reversing. We are getting poorer and poorer. Okay? When was the last time you see people coming in to buy the milk powder? That was before the COVID-19. Well, when the train starts again, will they come in here to get the milk powder now? Probably at a much less scale. They will all queue up in Tsim Sha Tsui to buy the expensive bags, to buy the land, to buy the cubicles. Whereas we will be servants. What I'm trying to say this to you is that you are now being faced with a situation when we are dealing with probate, probably in your lifetime, the kind of probate that we need to apply for and deal with will be a new mixture, an entirely new mixture, which is beyond your recognition presently. That takes us to the probate development. One thing which troubles us all the time is the language. We talk about language, we mean the official language. Before 1997 is English. Before 1997, in fact it was before 1995, when we still have Section 5 subsection 2, when the old version of the Section 5 subsection 2 as an informal will making by people in China, by Chinese in Chinese language. There was the old version before 1995. Since 1995, which is the present law now, then Section 5 subsection 2 has been modified to mean informal will to be made by any people in Hong Kong, in any language. So you can see the changes. And then, if you look at Rule 29, which is a common law concept, but is codified in one way or referred to in one way in Rule 29 of Cap 10A, that's talking about executor. Before 1997, it was the understanding that there is no such term in Chinese as an executor in English. So when you have a will which is not in English, that means you don't have an executor, quote unquote. And then in Rule 19 of Cap 10A, you see the concept, the term executor according to the tenor. Executor according to the tenor, meaning according to the content of the will. So if some kind of description is provided in the will, which normally is not in English, then if the function of the person nominated is such that he or she is expected to carry on the duty of estate administration, then we say, even though in languages other than English, we don't have an executor per se, but we may still have an executor according to the meanings, according to the wordings in the will, if it is sufficient connected with administration of estate. So we call these persons executor according to the tenor of the will. Then, after 1997, official languages in Hong Kong has been expanded to include both English and Chinese. This is our present situation. So, it is now permissible that even in a will which is not in English, we can still formally designate and appoint a person as the executor. 遺囑執行人. Now, you don't have to persuade the court. They will have to accept it for granted that this Chinese term carries on the exact meaning as executor. You don't need to rely on the term executor according to the tenor of the will. You may or may not be able to appreciate the significance, but when it comes to our discussion on Rule 19, you will soon find the differences. Particularly when these days you are entitled to apply for a grant to be issued in Chinese or to have a grant to be issued in English. Apart from the differences in the language to be used, it has in fact brushed away a lot of the possible legal implications. Let us take one step further. Can you imagine, let's say in your lifetime, or in the next 5 years, when the law of Hong Kong will further be changed to say the official language from now on will be Chinese and Chinese only? Well, probably this evening you may think that this is totally inconceivable. But these are politics, not law. I mean legal sense. If, well, an order is to be made for this to be changed, I don't think there's any objection can be made. If once that is happened, then it may take us to another crossroad, which is, can we not have common law in Chinese and in Chinese alone? That will bring us to a funny situation which is yet different from Singapore. Singapore, they are using common law. They have no burden about this civil law system at all. So these are the things that we will have to bear in mind. And against that background, then we have simplified small administration. If the Hong Kong dollar is to be deflated by 10 times, the same kind of ceiling on summary administration that we have just mentioned on HAD 50,000 and probate registry 150,000 will mean a substantial expansion of summary administration. Or alternatively, if the authority were to decide to expand it by way of administration decision, 50,000 now extended to 500,000, 150,000 expanded to 1.5 million. So all these are things which is lying ahead and which may be just around the corner. So the thing that I want you all to pay attention to is on this rapidly ever-changing area, how is it going to affect our probate practice? That is the thing that you need to mention and you need to be aware of. A small illustration in terms of the differences in the Chinese and English can be found in Rule 19. I may have mentioned to the class before, and now I emphasize again. We have been having all kinds of problems by saying what kind of capacity is the applicant when a person dies with a will. Okay? In a while, we will know about the priority for grant. Well, how is the English priority different from the Chinese priority? In the examination in this assignment, your discussion on priority must be based on the English version. And what are the differences between the English version and the Chinese version? By and large, they have no difference. It's only when you come to the subtle point that you see the differences, and it may change a lot of problem. Some of the problems that we are facing with when an applicant applying for a grant with will, which means probate, or LA with will annex. In English, you will be confronted with all kinds of differences on the nature of the gift. On the one hand, you have device. On the other hand, you have bequest. One is on immovable property, device. The other is on movable property, which is bequest. And then, if this is a beneficiary, you have to distinguish, well, is it a beneficiary of movable gift or immovable gift? For a beneficiary, then you may have a reference to the beneficiary being known as the legatee, similar to legacy. So a legatee is a beneficiary of movable assets. If it is a beneficiary of immovable property, then we'll have DYC. So noun is legatee or DYC. Verb is a bequest or device. Then if this is in terms of the assets, then you will have the legacy or the device. Sometimes it's not absolutely sure when one is using a verb, a word in or a term in the general meaning or the express or specific meaning. This I mean legacy. What exactly do we mean by legacy? A lot of time in the module of succession, we have to look at it at the particular context. The same way like you do it with probate. Does it mean generally a grant? Or does it mean a grant in the special sense when somebody died with a will and applied for by an executor? No. All these are matters that we must have a clear mind when things are expressed in English. I was trying to explain to the class a while ago on the English and Chinese discrepancy on this gift, meaning legacy. In Chinese, when you look at Rule 19, a gift is 违贈. You can use Rule 19 as a 违贈, but then there's no distinction between the kind of different nature of the gift. It doesn't have any distinction when it comes to movable or immovable gift, to be precise. Although in some sense the wordings are trying to follow it, but then 違贈 is simply good enough. So this is one area of conflict, a lot of time confusing us. And to make things even worse for you guys is like when you are now exposing to Greater Bay Area inheritance succession, then you have to be extremely careful. Using the concept of domicile in the way that Hong Kong is using. So you may have a domicile in Hong Kong or you may have a domicile in the mainland. The same kind of domicile in Chinese is called 居所地. It may not have a similar meaning. It may not have a similar meaning. So, when it comes to this kind of conflict of law, it will be very difficult to see if there are conflicting testamentary documents, one made in the mainland, one made in Hong Kong, which is to be prevail. What does it mean? When you have something called 違贈, which in the PLC in the mainland does not have the same meaning as a will. It's only a very specified type of gift by will. It does not mean testamentary gift as a general understanding. So therefore, you will need to be very sharp constantly to see which is the applicable term on domicile or 居所地, and then which is the document forced to be chosen for succession. This kind of problem will be very serious and acute, and we will continue to have and create lots of problems for us insofar as the Greater Bay Area are fast developing into one area. And also when we will have a different types of family structure. So these are the challenges faced by you guys in your lifetime. No one can predict what will happen, but things are happening now like this. The kind of problem that I have faced concerning this cross-border issue, one case that I have considered is when someone died in Hong Kong, leaving property in Hong Kong and in the mainland, there are all kinds of struggle by beneficiaries within the same family, and they are siblings. And when you reduce the fight in terms of cash and bank, but into different kind of stuff, one in landed property, the other in landed property held under the name of limited company. This is one area of problem. because you are talking about the shows in action. You are talking about the chattels. You are talking about the shares. And it's the shares of a company, and the company is holding the landed property. So these are the kind of problems that you do not necessarily come to a conclusive decision. So these are the things that will be constantly around us. All right? So I say this to you at the beginning of these 3 lectures in order to draw your attention to constantly different result and therefore different approach. And back to HAD. HAD, since 2006, Home Affairs Department, simple administration. The thing we need to remember here, it is the second branch of the second administration after the one initially done by the probate registry at the ceiling of 150,000. Nature, similar. On HAD, here, there is nothing to do with indebtedness. Okay, no debt. Any debt involved cannot be done by HAD, even though the money involved, the asset involved, is under 50,000. So it has to be simple in nature. Apart from no debt, the asset cannot be complicated. Very simple. Cash or cash in bank. Only. No grant issue. HAD also deal with safe deposit box, taking inventory. They have in fact taken over the job previously done by IRD. On this part of the work on the taking of inventory from safe deposit box, it doesn't really matter when the deceased died. As long as the deceased, you apply for a grant, you apply after 2006, then you have to go to HAD. So this is what we are obliged to do these days. We mentioned before, HAD also deals with funeral expenses. Remember, the one thing that we need to remember is HAD, funeral expenses, no reimbursement possible. So, if there is a need for payment of funeral expenses to be expended, to be used, to be paid, okay, HAD possible. But if someone has already paid for the funeral expenses, now you take the receipt and ask for reimbursement by way of this arrangement with HAD, this will not be accepted. Okay? This is only fresh payment for unpaid funeral expenses, not yet incurred. Once incurred and paid for, no more reimbursement possible. Maintenance. This is similar to what we discussed last time in lecture 6 about application for maintenance under Cap Void 1. There is a similar service to be applied for with HAD, except here with HAD you will have to prove your primary entitlement, either testate or intestate. So in other words, you will need to show that you are a person having beneficial interest in the estate, either testate or intestate. You cannot make an application like, say, I'm a cohabitee. It will not be possible with HAD application. So usually, if on intestate basis, it will usually be a spouse and the kids, or old parents. You may take advantage of this share entitlement so as to include spouse and parent, etc. We have briefly mentioned about the term official administrator, which is another capacity carried on by the registrar. One of the functions, as we have just discussed, is for summary administration in the probate registry for estate not exceeding 150,000. These are the several terms that I think we need to bear in mind in order not to be confused. When you look at the specified forms, which we shall visit in a while, there is always this term affirmation or affidavit, or affirmation/affidavit. It is very confusing. Very confusing. It has the same legal implication. You stay under certain ceremony, give some statement of information, and if it subsequently turns out that you are not telling the truth, then you'll be liable for the consequence, such as giving false information under oath. Affirmation is something along that line. For one to give a statement under oath, if the affirmant has no Christian belief, either no religion or no Christianity. So you give an affirmation. Affidavit is a similar term, similar meaning, but refer to the person who has Christianity, who is a Christian, who is a Protestant or a Catholic, a Christian. So technically, if someone were to give information to the effect that he is to be held liable, then it may either be affirmation or affidavit, depending on his religious belief. That's it. The same legal implication on default will be liable if he does not tell the truth. So when you look at the textbook, it may either be, sometimes use affirmation, sometimes use affidavit, and sometimes it's confusing. Like if you follow the white book, the Hong Kong Civil Procedure, then a lot of time it says affidavit. In the specified form, sometimes it says affidavit of identity, or affirmation/affidavit of identity. So, strictly speaking, you have to make a choice. to suit the particulars of the person who is going to affirm or who is going to swear. Grant application, the short term is a grant. The full term is grant of representation. So it is a general grant, sometimes in layman terms, probate. So it may either be probate, specified sense, or letters of administration with will annex, or letters of administration. Next, the term issue. Again, you don't have to be so technical. I mentioned to you just to let you be aware of this possible technicality. Issue is a term used in succession referring to those beneficiaries who is entitled to inherit when a deceased died without a will, meaning intestate. In other words, it is the beneficiary or the possible beneficiary under the rule of intestacy. It would be fair to say that you do not describe a beneficiary under a will as issue. Okay? He is a beneficiary or testamentary beneficiary. He is not a issue. The other thing is, you use the term issue to include one or more issue. You do not say issues. No S at the end. Having said that, don't argue with your boss if you find the term issues within succession of probate. Because even these days, quite frequently, you see judgments by probate judge. They also use this term issues, which according to what Mr. Wong has just said is wrong. But since they have used it, it must be right. But since you are not the judge, so probably it will be much preferable for you to keep to the term issue without an S. So, to put it within context, then you can say, what are the issues among the issue? Meaning, what are the problems among the beneficiaries on intestate? That is what it means. Okay? Last time I mentioned to the class about statutory trust, you must have an S. Here, to the contrary, issue is preferred not to have an S. Next of kin is another term which we should bear in mind. Next of kin will be beneficiaries on intestacy or potential beneficiaries on intestacy. If you recall this slide, there were item 1 to 9. It's only item 1 to 8 that we said they are next of kin, meaning the close relatives capable of inheritance according to the rule of intestacy of someone who died without a will. The government, as Vulnerable Kenshia, is not a next of issue, a next of kin. In order to have priority to apply for a grant, just next of kin is not enough. In order to have priority to apply for a grant under Rule 21 of Cap 10A, the non-contention probate rules, one needs to qualify as a next of kin with beneficial interest. So on the one hand, please remember, a next of kin is just potential intestate beneficiary. Whereas next of kin with beneficial interest are those actually having a claim to inherit at the time when the grant is made. Now, we are always faced with this concept of transiency, a transient state, date of death, date of grant application, date of distribution. The same answer may have different results when asked at these three different stages. So, if we say, okay, let's look at Rule 21 for next of kin with beneficial interest, then at day of death, it may be that the deceased has died, leaving assets under $500,000. Intestate, only $500,000 in terms of residual estate, and survived by spouse, issue, and parent. In a situation like this, at day of death, we have value under 50 million, under $500,000. So immediately we say in terms of inheritance, although legally there may be share entitlement, but the estate is so small, everything will go to the surviving spouse as statutory legacy. So the issue, the parent, they are not next of kin with beneficial interest. They are just next of kin. Whereas the spouse is a next of kin with beneficial interest. If that is the case, then we will soon be studying that Rule 21 on intestate priority. The condition present must be a next of kin with beneficial interest. So if you are saying, look, this is $500,000, not exceeding, and survived by spouse and issue, and the issue are now fighting with the spouse in terms of the applying for LA, then immediately you can say no. Spouse is next of kin because she has beneficial interest. Whereas issue, they have nothing to share, nothing to inherit, because everything goes under statutory legacy to the surviving spouse. So nothing left behind to be inherited to the issue at all. So therefore, they are not next of kin with beneficial interest, though there is no fight. Even if there is renunciation and whatnot, you still fail to satisfy this requirement as next of kin with beneficial interest. So you look at the same question again when you move on to grant application. As it happened to Hong Kong in our real life. Someone died 10 years ago. Grant applied for 10 years now, later. Value has increased considerably if there is landed property. So you can argue now the value of the estate maybe at time of death is only 500,000, but we have to bear in mind what is stated in the oath is simply representing in those old days where there is an obligation to participate in estate duty clearance. You look at the day of death in order to decide whether there is a need to pay estate duty or not. The same figure does not mean that it remains the case that the spouse is the only person entitled to inherit. Because 10 years later when you make an application for grant, now the value has increased to from 500,000 to 5 million. If this 5 million, then it's easy and legal and correct to say that this is a share entitlement between spouse and issue. So these are the things that you have to bear in mind on the time of looking at the size of the estate. It's that at the time when you make a grant that you need to convince the court as to whether this is sole entitlement or share entitlement. Personal representative, I've already explained briefly about this, including executor and an administrator. Official solicitor is something that we need to be careful not to be confused with official administrator. These are two different concepts. Official solicitor, this capacity is held by the Director of Legal Aid. Director of Legal Aid, one capacity, and another official capacity carried on by the Director of Legal Aid is the official solicitor. Sometimes they got involved in estate administration, succession, particularly when there are disputes. That usually happens when there are disputes and there are minority interests, whereas someone needs to represent the estate or the minors. Then sometimes the official solicitor will step in. So I just want you to be aware of this possible confusion on OS and OA. They are not the same, but then you need to address them as the official solicitor or the official administrator, although they are not the same. Now back to the probate registry, the kind of services that they provide. Summary administration we have just discussed. This is summary administration for small estate, 150,000 as a cap. The focus of work done by probate registry is non-contentious grant application. That would include normal non-contentious grant application, as well as grant application that was at one time contentious, having been decided by the court, goes back and changed back to non-contentious by reason of court order, and then people again make a grant that is also included in this non-contentious grant application. So in other words, item 2 will include those from day 1 is non-contentious, as well as those that somehow change at day 2 into non-contentious. A useful function done at the probate registry is search. This is a function that you guys should be able to do even now. Anyone can go to the probate registry, pay a small fee, and search at the computer station in the probate registry for these 3 types of information This is very useful and should be able to be done by every one of you without any supervision. All you need is some practice. 1. Grant application. You want to see, according to the record of the probate registry, is there anyone who has made any, in respect of any deceased? You key in the name and the ID card, if possible. Then you will see whether there is any pending grant application, as well as any grant application already made. So it is a good preliminary step for us to commence this grant application process when you know that there are or may be possible disputes by different family members. Similarly, you can make a search of caveat. Caveat is used very widely in Hong Kong by all kinds of institutions. A lot of time abuse. Caveat is a stop notice, meaning you give a stop notice to the probate registry as long as it is valid. The probate registry will not issue a grant unless and until the caveat ceases to be of effect. Either when it has expired or when it is cleared. Then we have citation. Citation is the third procedural matters that you can handle. There are strictly 3 different types of citation. Only one such type of citation, meaning 1 out of the 3, is now being known as constructive renunciation. We'll explain this term later on. So item 3 on search, something you can done all in one go. There is a certain time limit. I'm not sure how long, maybe 15 minutes or 20 minutes or something like this for each search. So if your fingers are moving fast, you can search all these 3 types within any one attempt. Number 4, to actually issue a caveat or issue a citation. Now, when we say non-contentious probate business, this is a term defined by Captain A, the non-contentious probate rules. By definition, anything not contentious, as well as 2 contentious procedure, namely caveat as well as citation. The 3 of them are defined as non-contentious probate business and to be done and decided by the probate registry, usually if dispute by the probate master. You don't go to the probate court all the way up. Number 5, any other ancillary matters. This will be like you want to apply for a certified copy of the will, a certified copy of the grant, so on and so forth. So by and large, if you are or you are hoping to be a probate practitioner, always get familiarized with the probate registry and take a visit there and try to see how all these are being performed. Okay? Probate registry application. So this is the booklet which I have been suggested the class to look at. So this is the booklet that you can see. Go online and try to read them. By about 10 to 20 minutes, you will be able to understand very briefly in terms of grant application and the kind of work that needs to be understood. So this is a very useful booklet, particularly for some of us are laymen. You just go through them. And this is all to be read very casually. These are one of the two simple booklets for those of us who wants to have a quick understanding of the work done by the probate registry as well as on grant application. You can get this in Chinese as well. Summary administration, applicant in person at the probate registry to the official administrator. Item 2, personal application by the applicant in person to the registrar for grant. Number 3, normal grant application through solicitor firms at the probate registry to the registrar. So this is how people can apply for at the probate registry, either for a formal grant or for a summary administration. Estate duty. If you, by chance, are applying for grant of someone who have died long time ago, namely before 2006, then you still have to perform the estate duty clearance process, even though you make the grant application now. After 2006, estate duty clearance has been abolished, So it's not post 2000. It's not post 2006 grant application, but post 2006 death that draw the distinction between the need for estate duty clearance or not. For deceased who died after 2006, which is more and more popular these days, then no more estate duty clearance are required, but instead you need to have disclosure of assets. As to whether or not estate duty will be reintroduced back to Hong Kong, there is always such a possibility, particularly when the revenue is on the downturn. When landed property are going down lower and lower in terms of value, the government will be quick to reintroduce different tax source. So it may be stamp duty, it may be rate, and it may be estate duty being reintroduced, or if it should happen, well, another form of simplified duty. Estate duty is one of the, if not the, is one of the most difficult statute to be understood in Hong Kong. It's so funny and ironic because we are using or following the Finance Act back in the 1800s in the UK, when in the UK they have long abolished it. But then we have to use these archaic terms with the leading legal confusion, so that one is troubled all the time on this very difficult concept on estate duty. Hopefully, if one of these days we need to explain our tax source, revenue source, then if there are duty to be reintroduced back in Hong Kong, an option will be to introduce not as estate duty to be taxed from the source of the estate, but rather from the point of view of the recipient. He who receives something will pay, just like a gift tax. So that will be much simplified, and that will also apply to stamp duty. We have a very difficult case on Shirley Wong's case on stamp duty, decided by the Court of Appeal, that reflected the difficulty faced by the court and faced by the ILD on stamp duty. Again, this is a second piece of statute after estate duty ordinance, also copied from the English authority, tax authorities. So estate duty and stamp duty are the two statutes copied from the UK when they don't have it anymore. And one will find it very difficult to argue that these are part of the common law situation. You cannot ask at the pretense of that, oh, this is coming from the UK and therefore this is part of the common law. This is not the case. It's just a matter of tax law. And there are also very sound arguments against this under the umbrella of common law, because in the United States of America they don't have this. They have different sets of tax law. So therefore it's all locally originated. So if we were to come back to a need to tax on change of asset, change hand of asset by reason of death, then we are always entitled to create something much simpler. You can draw as much tax on a different rate, but then the process can be much simpler, and the way to measure how much is to be paid and paid by whom can be created by a new set of statutes that will apply for estate duty as well as stamp duty. Okay, let's take a break now.